So just a reminder for some of you who are joining for the first time, who were not here last week, just a reminder of the importance of that diagram on page 6 of your tutorial letter, tutorial letter 102. I keep on referring to it as the study guide. So if I keep saying study guide, that is the document that I'm actually referring to. As Prof has indicated, that diagram is basically just a summary of everything that's going to be covered in this module. So please continually refer to it in your preparations. It will also just help you to understand which work you've covered when you're studying for your exam. And then just a reminder that this is a tutorial and it doesn't necessarily substitute your lectures, which are held on Tuesdays from 2 to 4. So the aim of these tutorials is basically just to facilitate your understanding, and it's in addition to your lectures, which are held on Tuesday. Some people are not able to actually attend the lectures due to work commitments and other things. So yeah, that is the primary class. That is the lecture that is held on Tuesdays, but these tutorials are basically held on Mondays and Tuesdays from 6 until 8, just to assist you with the course material, and it's over and above your lectures. And then another question that keeps popping up is whether these tutorials are recorded. They are recorded, as Godfrey has said. And the links will be provided by him once they've been edited. So they go through a process of editing so that they can meet the UNISA standards. So once all edits have been done, then those recordings are made available to you. So they will be made available. And then without further ado, colleagues, last week I asked if any of you could please just prepare a 10-minute discussion on the separation of powers, what you understand by the separation of powers. So before we proceed with the tutorial, is anyone volunteering to just give us just a brief summary of what they understand the separation of powers to be, what it entails, a brief 10 minutes or less? Is anyone willing? By raising your hand, any volunteers?
But my understanding of separation of power is about abuse of power by the executive, the judiciary, and the legislature. That it limits powers from each of the three, and there are checks and balances so that there is no abuse of power to the citizens. So it tries to
100%.
Yeah, it tries to limit power from each one of them, either from the executive or from judiciary or from the legislature. However, as much as I'm saying that, I still have a question, because the executive is from the legislature. Now, I heard the current Speaker of Parliament saying the executive, it's still part of the legislature. And for me, it was like, now there is a contradiction from the doctrine of separation of powers. I think that's the long and short. I know it's not that enough for me to pass the examination.
Yeah, I'm sure out of something good. I'll address what you said regarding the separation of powers, executive and legislature, but I see there is another hand up.
Okay, mine is not as detailed either, but it's based off of my knowledge of the concept. So from the previous semester, well, I understood that there are first different types of separation of powers and stuff. So there's the horizontal separation of powers, which include the legislature, executive, and judiciary. Then there's a vertical separation, and then there's functional separation of powers. Those are the only three I know. I think there's more of it, but those are the only three I know. And in simple terms, the legislature is basically they're responsible for making laws, which includes parliament, the provincial and local rights. And then there's the executive, which is it's sort of the president, his cabinet, ministers, executive branches, policies and everything. And then there's the judiciary, which they interpret the law and they sort of to some extent administer it, right? Those fall under the first heading that I mentioned, the horizontal separation, right? So in simple terms, horizontal separation is when power is separated between the three groups, specifically branches. And then vertical, it involves distributing it between the levels of government, which are national, regional, and local.
Yes.
And then there's the functional separation. Well, I'm not really sure what the functional does, but based off of the research I could conclude on it is that it refers to the division of powers specifically within the government. So it's sort of like responsibilities distributed in detail or in specification based off the capabilities of that sector.
Yes. Yes. You've even taken it a step further to actually give us the other types of separation of powers. Very impressive. Yes, that was very informative. You are 100% correct in how you've described all of them: the horizontal, the vertical, and the functional. So yes, 100%.
I think I'll just add but I will agree mostly with the last student what she have said, but I'll just say what I understand. According to me, the separation of powers is about the three branches of government, which is firstly the legislature. When we talk about the legislature, we're talking about the National Assembly. And then when we talk about the executive, we're talking about the cabinet ministers, which is headed by the president. And when we speak about the judiciary, we speak about the courts and everything that has got to do with the law and court and everything. What I want to add is that the judiciary is independent. It's independent from the executive and National Assembly. Further than that, all of them, they do have some functionaries, how they function, what is it, what does the legislature does, and what does the executive does, and what does the judiciary do. But added to judiciary, I would say that the NPA, although also it is independent, but it's mostly part of the judiciary. But none of them can tell each other what to do. So they are all independent. Lastly, I would say that the president is the chairperson of the cabinet ministers. He deals with cabinet ministers. Maybe let me just hold it there. But there's quite a lot of functions, and it goes down. Each and every one has got some limits. But there can be also that if there is some challenges or conflict that arises from local government, the provincial government has got the right to interfere with local government in terms of the what do you call it? In terms of the multi-sphere, in terms of the multi-sphere government. That is resolving the issues that arose from the local government in terms of intervention. Thank you.
100%. Yeah, no, that is a very good summary of it. You even took it a step further to talk about the spheres of government, just like Esmahlangu did, in terms of that vertical relationship that takes place. And yes, you've essentially summarized it very well, just the different functions of the different levels, the different functions of the three branches of government. So yes, that is correct. Thank you for that, guys. Thank you for the participation. So I'm not going to spend too much time on the separation of powers because we did do it last week, and also this week your colleagues have given us quite a good summary of what it actually entails. What we are going to do today is just a bit of the separation of powers, and then I'm going to jump straight into chapter 4, which is the national legislature. So the first part of the tutorial is going to be dealing with separation of powers, just a recap, just to remind you about what it entails, and then we will move on to the national legislature part 1, and then we'll continue with part 2 tomorrow. So yes, so as correctly indicated, colleagues, the separation of powers, by way of definition, it is a doctrine which entails the institutional division of public power between the 3 branches of government, namely the legislature, the executive, and the judiciary, to limit power. As correctly mentioned by Josiah, he talked about that abuse, and that's a central part actually of why we have a separation of powers, to avoid abuse. And we talk about it here under purpose, where we say it's to create a society in which abuse of power by government is curtailed and public power is exercised appropriately. It ensures predictability and transparency, and that power is not concentrated in one branch, person, or office. So when you look at it, if the entire power of the state was vested just in one branch of government, it would leave it open to abuse, because then there are no checks and balances that are taking place. There's no disciplining that's taking place. So a big part, or a central part, of the separation of powers is to avoid abuse, for the protection of all the inhabitants of a state, to ensure that government functions appropriately. And then in one of the cases, Glenister versus President of the Republic of South Africa, they just reiterated there that no provision of the Constitution actually makes reference. So this is important to note. You're not going to go into your Constitution and find a section or a schedule that's actually saying this is the separation of powers. No, there's nothing like that. But we can just see by the arrangement of the Constitution that there are actually 3 branches of government. And we see with how the sections are arranged that it's dealing with the legislature, it's dealing with the executive, it's dealing with the judiciary. So that is just, an introduction as to definition and the purpose. And then part of understanding the separation of powers entails understanding the difference between the state and government. So I know we tend to use these 2 terms interchangeably, which is not always correct because they are different. And just to give understanding on that, a state is a permanent object with certain features. So as we can see here, a state is a sovereign jurisdiction, and what it has is a specifically defined territory. It's got a community of people who live within a territory. It's got a legal order to which the community is subject. It's got an organized system of government able to uphold the legal order. So for example, South Africa has got its own political identity known as the Republic of South Africa, or you've got the Kingdom of Eswatini, or you've got Kenya, or you've got the United States of America. So all of those define a state that is a standalone, or it's sovereign. It stands on its own. It's got its own identity, and it carries these features. Now, when it comes to government, government is actually the body that governs the state. So you've got the state, which is a permanent fixture, and then you've got government, which actually governs the state and how the state is operated. So the government changes when regular elections are held. This impacts on the composition of the legislature and the executive. Not so much the courts, because as correctly indicated, the courts need to remain independent, so they cannot be politically affiliated. Judges cannot be seen to be politically affiliated with any specific party. They always need to be independent and impartial in order to effect the proper operation of the country, proper administration of justice. The courts and all its officers at all times need to be independent and impartial. So that's just the difference between a state and the government that governs the state. Okay, then we spoke about this last week. These are the pillars of the separation of powers. So this is what actually makes the separation of powers work. We've got the principle of trias politica, which is the actual division. So that's where we divide government into the three branches. Yeah, so the principle of trias, or the doctrine of trias politica, is the actual division where government is divided into three branches, namely the legislative branch, the executive branch, and the judicial branch. Then you've got a separation of functions, because as we said last week, it doesn't help to just divide government. You actually need to give each branch its own set of functions and responsibilities that they assume. So that just goes into conferring different areas of responsibility and authority on each branch. And then a separation of personnel, which basically tells each branch having assigned to it specific persons who are responsible for the performance of the functions of that branch. Then we've got checks and balances, things that Josiah also mentioned, where one branch can be held accountable by other branches to check the exercise of power by that branch. And that goes to addressing that abuse element to ensure that one branch is not abusing its powers, it's exercising its authority appropriately. But it's an important point that one of you mentioned, I can't recall who, but you spoke about interference. And yeah, there can sometimes be a thin line between interference with the other branches and exercising your checks and balances. And the courts are very helpful in actually lining up or explaining where what would constitute an interference and what would actually constitute just a mere check and balance. Obviously, they can't do that in respect of themselves, but when it's in relation to the legislature and the executive, some matters do go to court to actually determine whether it was an interference or it was merely a check and balance that was being exercised. Okay, and then just an overview of what each branch of government actually does, what their function is, and what is their composition. First, the legislature, and their main function is to debate, draft, amend, and repeal laws. And also an important function that they have, which goes to checks and balances as well, is to hold the executive accountable. So that is a very important function that the legislature actually exercises. Then the National Assembly is composed of 400 representatives, known as MPs, who represent all political parties that reach the required threshold of votes in proportion to the overall number of seats. We'll go into that as well, how that is calculated. And then at the first sitting after an election, the president is elected. And this goes to one of the questions that was raised in the beginning, where it was mentioned that the executive or members of cabinet are also members of the legislature, which is, it's not correct, well, depending on what point in time you're looking at. So as we said, after an election, you've got your MPs. Then what happens is the president is elected, and as soon as that election takes place, so as soon as Mr. Ramaphosa is elected as the president, he ceases to be a member of the legislature. So he's the member of the legislature up until that point, and then as soon as he is elected, then he moves over, also together with the members of cabinet, they move over to being members of the executive. So they are members of parliament up to a point, then they become members of the executive. But after that, while they are in office for the 5-year term, they are members of the executive and not the legislature. Otherwise, that would be an infringement of the doctrine of the separation of powers. And then, yes, any MP may introduce legislation to be debated and passed. That is a right that the members of parliament have. Moving over to the executive, their main function is the implementation of legislation passed by the legislature. They're also responsible for making policies. They implement and administer the law, and they make crucial appointments, as we're going to see under the judiciary. And it comprises the department as the president as the head of the executive of the executive and state, as well as the deputy president and the cabinet of ministers. The president has the power to appoint and dismiss cabinet. However, the president must remain accountable, responsive, and open, and act under the principle of legality and act rationally. Otherwise, exercise of public power may be set aside by the CC. So very important when it comes to these reshuffles of cabinet, the president cannot just do that willy-nilly or just however they want. They still need to remain accountable, responsive, and open, and that's just a limitation of that power. And then the executive is accountable to Parliament and must report to it regularly. Parliament may remove the executive. So that's another important feature that we mentioned, where there's a checks and balances, where Parliament can actually question the president. They can question specific ministers about their portfolios. That is just to ensure that, again, authority is being exercised appropriately. Functions are being undertaken in accordance with the law, in accordance with the various portfolios. And then we've got the judiciary. Their function is to interpret and adjudicate legal disputes and declare invalid laws of the legislature which contravene the constitution. Very important check and balance. That's actually one of the most important checks and balances that the judiciary can actually effect, is to declare laws or conduct. So it's not just laws, but it's also conduct invalid if it infringes on the constitution. It comprises magistrates, judges, and justices, and various courts. And then the judiciary may not intervene or interfere in the legislative process until it is completed, unless no other remedies are available and the harm caused would be material and irreversible. So we see here again how the separation of powers is applied in practice. So the judiciary cannot just intervene while the legislature is busy compiling a bill and put a stop to that process, unless by proceeding with that bill, there would be irreparable harm that is caused, material harm that is caused. So that's just to ensure that the Constitution is always upheld at all times. Okay, and then in the case of Oriani and Brosini, we're going to discuss it later on in the tutorial as well. And the court declared rules of the National Assembly unconstitutional, as they did not allow ordinary MPs to introduce legislation. So a very important function that the judiciary has in intervening in the legislative process, where it's permissible. And then judges are appointed by the president. After extensive interviews with the Judicial Services Commission. Judicial officers must remain independent and impartial. Very important character or principle of the judiciary is that it has to be independent and impartial. It cannot be influenced, otherwise that would lead to injustice. And then judges are guaranteed security of tenure, and salaries may not be reduced. Judges may be removed through investigation by the JSC. So there's a pivotal role that the JSC plays in appointments as well as the removal of judges, and also by way of recommendations to the president about appointments and even promotions, for example, SC, Senior Counsel. Okay, that is the overview. This is just a summary. This is extracted from your tutorial letter / study guide, just about the structure of national government. So again, the separation of powers, national parliament, in terms of Chapter 4 of the Constitution, Parliament consists of the National Assembly and the National Council of Provinces. So Parliament is not just one house, but it's two houses. It's bicameral. We're going to discuss that later on in the tutorial. But to always bear in mind, I know that when we talk about Parliament or we talk about the legislature, we always talk about National Assembly, but it's not the only house. There's also the National Council of Provinces that forms part of national Parliament, the national legislature. It's not at a provincial level, it's at national level. And its members are the people's representatives, and it is the highest lawmaking authority in the country. We've got the national executive covered under Chapter 5 of the Constitution. That is in respect of the president and the ministers who together form the cabinet. The ministers are the political heads of different government portfolios and perform executive functions. So for example, the portfolio for health, the portfolio for agriculture, and so forth. And then we've got the judiciary, which is the authority that is vested in the courts, and this is covered under Chapter 8 of the Constitution. Courts exercise judicial review of law or conduct, and to do this effectively, the courts must be independent and be subject only to the law and the Constitution, which they must apply without fear, favor, or prejudice. So that's just another summary of the structures at play and where you can find those specific chapters in the Constitution. Okay, then coming to checks and balances, this was mentioned in the beginning. So these are basically restraints which are exercised by one branch of government over another to ensure that the branches of government do not usurp power one from another. This necessitates the unavoidable intrusion of one branch on the terrain of another. It's a prominent feature of South Africa's democratic dispensation. It maintains an equilibrium in the exercise of power. And then in South Africa, we mainly see this through the judiciary, which is empowered to check whether the other branches comply with the law and exercise their authority in conformity with the Constitution, as we mentioned. So there are other examples of this, as we mentioned, but the main check and balance is the one that is exercised by the judiciary. But for example, as we said, in Parliament can actually call the executive, call any minister, call the president to come and answer specific questions about their portfolios, their respective portfolios, or any other matters. So that's another example of a check and balance that takes place. And again, the main function of this is just to ensure that there is no abuse of power and that authority is being exercised appropriately. So the various branches check each other. Okay, and then in the Doctors for Life International versus Speaker of the National Assembly and others case, this dealt with the intrusion by the judiciary in legislative matters. And in that case, it was stated that courts are required by the Constitution to ensure that all branches of government act within the law and fulfill their constitutional obligations. This court has been given the responsibility of being the ultimate guardian of the Constitution and its values. Section 167, subsection 4, subparagraph E, in particular, entrusts the court with the power to ensure that Parliament fulfills its constitutional obligations. And it goes on to say there may be a case where the protection intended to be afforded by the Constitution cannot be provided by the courts unless they intervene at an earlier stage. For instance, the consequences of the offending provision may be immediate and irreversible and give rise to substantial damage or prejudice. If such exceptional cases should arise, the need to give full effect to the Constitution might require the courts to intervene before the bill is enacted. In such a case, parliamentary privilege must yield to the court's duty to give the Constitution overriding primacy which it's due. So, as we discussed before, these are the only circumstances in which the intervention in the legislative process would be appropriate. And this essentially means that before the law is even passed, so even while it's still a bill or even while it's still being debated by Parliament, the judiciary would actually be entitled to intervene and say, we've noted that there are provisions in this bill or in this paper which are offensive to the Constitution, and if we leave this bill to run up until it is enacted into legislation, then there would be substantial damage or prejudice. So in those instances, the courts would be entitled to intervene. They would actually be entitled to enter into the terrain of the legislature and say, there are provisions that are unconstitutional here, there are provisions that would cause damage, please reconsider. But then again, it is up to the legislature to go and rewrite, to go and fix or to remove completely those offending provisions. It is not the court that would actually do that. And then in Minister of Health and Others versus Treatment Action Campaign, this was another intrusion by the judiciary in executive matters, and there it was stated that South African courts have a wide range of powers at their disposal to ensure that the Constitution is upheld. These include mandatory and structural interdicts. How they should exercise these powers depends on the circumstances of each particular case. Here, due regard must be paid to the roles of the legislature and the executive in a democracy. What must be made clear, however, is that when it is appropriate to do so, courts may, and if need be, must use their wide powers to make orders that effect policy as well as legislation. So another important principle that is being raised here, where it's basically saying that the judiciary can actually force the executive, they can intrude on the executive's terrain here and actually force the executive to do specific things. And in this specific case, Minister of Health and Others versus Treatment Action Campaign, this was to do with the South African HIV/AIDS activist organization, and they basically sued the Minister of Health for failing to make ARV drugs available to pregnant HIV-positive women. And the court actually ordered in that case that government must make the ARVs available. So even though it was the executive's function, and particularly the Department of Health, to make these ARVs available, even though it was an executive function, the courts actually intervened because they were approached to actually say, no, you need to make these antiretroviral drugs available to these pregnant women. Because at that time, if my memory serves me correctly, in terms of the case, they did indicate that giving ARVs to pregnant women would actually reduce the chances of them passing infection to their babies. So it was a very important thing that needed to be done. It went to the heart of human rights. And that is why the court actually was comfortable in intervening and saying and forcing the executive actually to make these drugs available. So that is where we see checks and balances in practice, where courts can actually intervene in the other branches of government. And we mostly see it with the courts, as is demonstrated in these cases. Okay. So in addition to the checks and balances that one branch can exercise over another, we do have oversight by independent institutions, which just check what the branches of government are doing, if there are any abuses taking place. And we are going to deal with these more in depth in Chapter 7. When we get to Chapter 7, we're going to go through all the institutions that basically have this responsibility. But in summary, these three, known as the Chapter 9 institutions, these have been established to ensure that the state operates in terms of the rule of law and deepen as well as safeguard and support democracy. So we've got the Office of the Public Protector, and its function is to investigate claims of abuse of power, unfair or rude treatment, unnecessary delays, non-adherence to rules, dishonest or improper handling of money, and personal gain through bribes and corruption. So that is how the public protector upholds democracy, by receiving complaints from anyone. Basically, any member of the public can actually approach the public protector with an allegation of any of these circumstances that have taken place. And then we've got the Auditor General, which is basically responsible. It's the only body or institution that is actually empowered or authorized to conduct audits and reports on how government expends their tax money. So they check in with different departments to see, has the money, for example, been allocated to the hospital as the Minister of Finance said it would be in the budget speech. They would be checking all those things, checking for irregular payments by municipalities, checking if everything that the municipalities are saying they bought, it was actually bought. And just checking that the financial books of government and various municipalities, various state-owned companies are in order. And then we've got the Independent Electoral Commission, which is responsible for managing elections to ensure that they are free and fair, as well as compiling and maintaining a voter's roll and declaring results of elections. So obviously this function of the Electoral Commission, it needs to be independent. Otherwise, again, it can fall prey to abuse. For example, if one party wants to be in power, so they need to remain independent at all times. And then we also have the National Prosecuting Authority, as one of our colleagues mentioned in the beginning, which ensures the effective functioning of the judicial system. We've also got the Judicial Services Commission, which has great involvement in the appointment and removal of judges. So those are some of the other bodies or institutions which actually support these branches of government being checked and balanced to ensure that what they are doing is appropriate. Okay, then this was just something interesting that I found, colleagues, which is happening in current affairs at the moment. I'm sure most of you would be aware if you're listening to the news, where the National Assembly has actually put forward or nominated Dr. Hlophe for a position in the Judicial Services Commission. And we actually see the separation of powers at work here, because 3 applications have been brought to actually halt the designation of Dr. Hlophe to the Judicial Services Commission. So they're basically trying to interdict him from being nominated to the Judicial Services Commission. And the reason for this, I guess, is quite clear. I mean, he was removed from the judiciary, basically impeached from the judiciary, and they're saying, how can you take someone who was removed from the judiciary and actually put them forward as a member of the Judicial Services Commission, because obviously that indicates that he does not uphold the values of the judiciary. So that is the concern that has been put forward in 3 separate applications that are actually being heard currently. And what one of the applications had indicated, it was the application by ATM, they indicated that the dispute involves important questions, and it is clear that these important questions relate to the separation of powers. So a court intervening in a matter that was voted for by the National Assembly and saying that the National Assembly acted irrationally, that touches at the heart of the separation of powers. And only the Constitutional Court can decide on such matters. So it's actually just quite interesting to see that this point has been raised, and from my perspective, this question is actually raised. It is quite interesting to see, because what you're getting here is, then you're saying the National Assembly has erred, or it hasn't done the right thing by putting his name forward, and we're interfering with that function of theirs to actually appoint members to the Judicial Services Commission. So yeah, that was just interesting from my side to see that it's actually put into play. We're seeing it in news every day. I'm sure the Constitutional Court sees many of these cases that touch on the separation of powers, relating to who can assume what position and such questions. So yeah, that was just an interesting thing from my perspective. And then we're moving on to the national legislature. Does anyone have any questions in terms of Chapter 3, the separation of powers, before we move on to Chapter 4? Okay, so moving on to the national legislature, colleagues, and please bear in mind here when I'm talking about this chapter of the textbook of the study guide, we're only talking at national level. So provincial legislatures we're still going to deal with. This is just dealing with content related to the national legislature itself, not the other spheres of government. Just to be clear on that, just in case you get confused with how we're breaking things down, or if you feel that we are not touching on certain things here, we're only dealing with the national legislature, which is chapter 4 of your your textbook and of your study guide as well. Okay, so this is dealt with on pages 54 to 70 of your study guide. And what is the national legislature? It's actually the lawmaking body of government. It is the highest lawmaking body of government. Its functions are to consider, pass, amend, or reject legislation on any subject that falls within its jurisdictional areas of competence. We are going to discuss further these jurisdictional areas of competence, because there is a distinction between how laws are passed in terms of different schedules in the Constitution, the involvement of the NCOP, the National Council of Provinces, and its role in passing legislation. Another function is to ensure that all executive organs of state in the national sphere of government are accountable to it. We've mentioned that in previous slides. It maintains oversight of the executive authority, including the implementation of legislation, and then it maintains oversight of any organ of state. It's also known as Parliament, and in this case of EFF, they summarized actually quite nicely what the Parliament should represent in a specific society. And they said that Parliament is the mouthpiece, the eyes, and the service delivery ensuring machinery of the people. No doubt it is an irreplaceable feature of good governance in South Africa. So that was just reiterating the importance of the legislature and its function, just in ensuring that service delivery actually occurs by the executive, that laws are actually implemented by the executive. It has a very important function there. And also just going back to pre-democracy times, how Parliament was actually used to enact laws that were discriminatory. That's why Parliament now has this important function of ensuring that they do pass laws that are in accordance with the Constitution. Otherwise, the courts can actually set aside their laws as unconstitutional and therefore invalid. Okay, so going into the electoral system and the national legislature, these two are very closely linked. So when we had our elections earlier this year, you need to understand what you are actually voting for, because sometimes we actually vote and we don't understand what we're voting for, or we don't understand how our vote works and how seats are assumed in Parliament. So what the connection first starts with political parties, which are central to our democratic system of government in South Africa. And the majority party in the National Assembly actually forms the government and also influences policy and the actions of the elected representatives in the legislature. So South Africa currently has a party proportional representation electoral system, and what that essentially means is that under a list system of proportional representation, it is parties and not individuals that are the electorate votes for, and parties which must be accountable to the electorate. And then prior to national and provincial elections, each political party holds a national elective conference. I'm sure you've heard about this a lot in the news. EFF is having its conference, ANC is having its conference, the DA is having its conference. MK did not have its conference. I think they delayed it. But yeah, essentially what happens during this conference is that members of the political parties nominate a list of candidates, ranking them in order of preference. Consequently, voters vote for a political party and not for individual candidates. And in this case of Democratic Alliance and another versus Masondo, it was stated that the Constitution does not envisage a mathematical form of democracy where the winner takes all until the next vote counting exercise occurs. Rather, it contemplates a pluralistic democracy where continuous respect is given to the rights of all to be heard and have their views considered. The open and deliberative nature of the process goes further than providing a dignified and meaningful role for all participants. It is calculated to produce better outcomes through subjecting laws and governmental action to the test of critical debate, rather than basing them on unilateral decision-making. So essentially, what this is covering, colleagues, is that each party will basically have their conference. They will put a list together, and anyone can actually go and have sight of that list and raise objections to it. But anyway, what they do have is a list which actually states the names of different people in order of preference. So obviously at number 1 for each party would be the person whom they want to be president. So for example, for the ANC, it would obviously be President Ramaphosa, who's number 1 at the list. So the list goes all the way down. It would go obviously until 400, because 400 seats are available. So you'd have your names. If you have that many people, you'd put your list together. Then what happens is you would have your election. So you and I go to the polls, we go and vote for whoever we want to be in government. And then once the election results come out, and for example, MK has 50% of the vote, meaning it will have 200 seats in the National Assembly. So it is always calculated in proportion to the outcome of the election. So they will vote, there'll be different percentages, of course, and then those percentages will translate directly into seats in the National Assembly. And that is why the National Assembly has different parties represented. Okay, and then just going to the advantages and disadvantages of that type of system. Advantages included being a simple and easy to administer. It reflects the wishes of voters more accurately than any other electoral systems. It is easier for small parties to be represented in the National Assembly. It eliminates possible artificial constituency boundaries, or also known as gerrymandering, that dilute political support in certain constituencies. It produces more inclusive legislatures and ensures better representation for marginalized or discriminated groups such as women and minorities. It also limits pork barrel politics, where politicians buy the support of voters in specific constituencies by pressuring the legislature and the executive to spend public money on projects such as clinics, roads, schools, and so on. Disadvantages include it not creating a strong link between voters and the elected representatives, which may cause a lack of responsiveness to voters, because it is a political party as a whole that needs to respond. So that just essentially means, colleagues, that because you and I don't vote for specific people, we actually vote for the party rather than voting for the individual who's actually going to sit in parliament. Sometimes that creates a disconnect between you or I as the voter and who actually sits in parliament and whether they actually represent us. Secondly, the leaders of political parties may have disproportionate influence over the way in which individual MPs behave. Too much power is given to the leaders of a party, who may be able to determine or influence who appears on electoral lists. It potentially produces a less effective and stable government, especially where one political party is not dominant, sometimes forcing fragile coalition governments. So yeah, that's just in relation to the electoral system and how it relates to the national legislature and how those seats in the National Assembly are actually obtained. Okay, now going to the structure of the national legislature, colleagues. Parliament, as I said, is bicameral, meaning that there are two houses. It's comprised of or composed of two houses. The first being the National Assembly, which is the more dominant house of parliament and the one that all of us know. And this one has far-reaching powers, as we are going to see in further discussions. And then we've also got the National Council of Provinces, and it has a less defined roles in holding the executive to account and has no role in the appointment or removal of MPs. So we're also going to discuss what exactly is the role of the National Council of Provinces, why does it sit at national level, and what is it there to do in Parliament. So just going to the benefits of bicameralism, or having two houses of parliament. This ensures that adequate democratic representation of different interests, namely the interests of the electorate in general by the National Assembly on the one hand, and the interests of the 9 provinces by the NCOP on the other hand. The workload is alleviated to enable the National Assembly to focus on matters of national concern. The different houses check on each other. So this system actually is quite beneficial in a society like ours, where corruption is rife, where checks and balances need to be in place, and that is why we've got 2 houses of parliament which actually check on each other, which can actually assist each other in the work that needs to be undertaken, and also to ensure that different point of views are heard when enacting legislation and deciding on specific matters. Okay, important colleagues, please don't confuse the National Council of Provinces with a national legislature. When we discuss it, that it will be clear why it is not part of the provincial legislatures, but please always bear in mind that the National Council of Provinces forms part of the national legislature. It is not part of the provincial legislature, even though it takes members from it, but it is not part of the provincial legislature. It's right at the top at the national level. And then each province will then have its own legislature. So for example, Gauteng will have its own legislature, Western Cape will have its own legislature, and so forth. Okay, so I'm not going to go into these cases. Please ensure that you do go and read up on these cases and what they're about. As I always say with your cases, please ensure that you do read the entire case, because oftentimes there are principles that we leave out or we omit because we've only read the head note. And the person who summarizes that head note is just like you and me. They are just legal professionals, so they can leave things out. That's why it's important to always ensure that you do read the cases in full to ensure that you understand the various principles that are being applied. Okay, so now we're moving on to the National Assembly, being the first dominant house of parliament or of the national legislature. Okay, so colleagues, the National Assembly comprises 400 members, as we indicated above. The manner of election, as aforementioned, members are elected via their respective political parties in a national election, like the one that happened earlier this year. The higher up on a political party's electoral list a person is ranked, the more likely it is that such person will be elected to go to the National Assembly or to form part and be a member of the National Assembly. So by way of example, if a party obtained 50% of the votes at the elections, it is allocated 200 of the 400 seats in the National Assembly, with the first 200 names on the party's list becoming MPs. It means the rest of them would then be excluded after the 200. Okay, then going to the function and role. The function of the National Assembly is the election and dismissal of the president. It is entitled to do that. They vote for the president, and then the president assumes office. They then leave the national legislature. They then leave the legislature to become a member of the executive, as we mentioned. Passing of legislation on any matter. It forms a national forum for public consideration of issues, participation in public meetings of the National Assembly, where they may ask questions of the members of the cabinet, what is referred to as question time, where ministers have to answer specific questions that are put to them, or the president has to answer questions. Scrutinize and hold all executive organs of state in the national sphere of government accountable to it. Maintain oversight of the exercise of the national executive authority, including the implementation of legislation, and especially the authority to use state resources and the spending of public money, which is why some of you will remember when there were concerns raised with the upgrades that were undertaken at the homestead of the former president, President Jacob Zuma. Those upgrades, security upgrades that had taken place, the fact that those were not appropriate, he had to answer on that in Parliament, and questions were put to him by the various members of Parliament, and they could basically ask him whatever, make whatever comments. So the President and the Cabinet have to subject themselves to Parliament and answer any questions that may be put to them in respect of their portfolios. And then they play a decisive role in various appointments, including commissioners of the Chapter 9 institutions, which we referred to earlier. And then the National Assembly also has portfolio committees for specific portfolios, for example, agriculture, basic education, and health. So there are various committees that are actually put together to address different topics such as agriculture, basic education, health, and any other such matters. Okay. And then the limits of the powers of the National Assembly. So the National Assembly must always act in an open and transparent manner and cannot make rules contrary to the constitutional requirement of openness. So we would remember that pre-democracy, the legislature was actually supreme. We had a principle of parliamentary sovereignty where Parliament could enact whatever laws they wanted, whether they were constitutional or not. This has been done away with, and actually all laws have to pass constitutional muster. So this is a limitation that is placed on the National Assembly to ensure that everything that they do is still constitutional. They cannot just make any rules that they want to make. And it goes back to the principle of constitutional supremacy. Members of the National Assembly, as well as cabinet members who appear before them, enjoy certain privileges which cannot be curtailed by a parliament or anyone else. We're going to go into a discussion on these privileges, but just bear in mind that members of the National Assembly, as well as cabinet members who are appearing before them, actually have privileges, and it's in relation to the freedom of speech, the freedom to not be held civilly or criminally liable, but we are going to have a discussion on that. So that is a limitation, that the National Assembly can actually not then go to court and say that someone said something in the National Assembly or the National Council of Provinces, because there is that exercise of the freedom of speech. And then the National Assembly is required to facilitate public involvement in their legislative and other processes. And this is actually entrenched in the Constitution. The public has to have involvement in what the legislature is doing, what the National Assembly is doing, what the National Council of Provinces is doing, to ensure that we know what is going on, that you and I as members of the public actually know what laws are going to be enacted. And if we want to give feedback, then we are actually able to do that, to see if it will be taken into consideration. And that just goes back to the point of being open and transparent. Everything that Parliament does, and specifically the National Assembly as well, has to be open and transparent so that the public can know what is actually going on, and that is entrenched in the Constitution. Okay, and then going to the role of the Speaker or Deputy Speaker of the National Assembly. You will always hear in Parliament when they're talking, they say Madam Speaker, Madam Speaker. So the Speaker in the National Assembly is actually the presiding officer. They preside over debates in the National Assembly. They have to be above party politics. So even though the Speaker may be affiliated with MK, for example, when they are making rulings and when they are presiding over debates, they cannot defer to their political affiliations. No, they always have to be impartial and objective in order for them to actually preside appropriately. So yeah, they talk about that impartiality being the type that is expected of a judge. So you can see that it's at a very high level that they have to exercise this function. They have to keep discipline in the NA and must rule on any objections lodged by members against the conduct of other members. So I'm sure you've seen this as well when you've watched snippets from Parliament, or if you do watch parliamentary TV, you will see that various rules are invoked by the speaker. For example, when someone speaks out of line, when an objection is raised, they have to address that in accordance with those rules of Parliament, and it is the speaker who is responsible for that. So they need to ensure that discipline, as much as freedom of speech is there still needs to be a level of discipline so that the National Assembly can actually carry out its functions and its duties appropriately. So the Speaker, jointly with the Chair of the National Council of Provinces, serve as the administrative heads of Parliament. And as the custodian of the rights and privileges of its members, the Speaker furthermore acts as the representative and spokesperson for the legislature and has the power to give an undertaking on behalf of the National Assembly. So very important, when you look at the Speaker, that is actually the representative of the legislature. They can bind the legislature in terms of various decisions that are undertaken. That's why you will see in some of the cases that the Speaker of the National Assembly is actually cited in that capacity when there is suing or when they are going to court on specific matters. They actually cite the Speaker of the National Assembly in that capacity. And then lastly, the Speaker may not exercise his or her discretion for the benefit of the Speaker or for the benefit of his or her party. Just going back to that first point where it's not about political affiliations, it's not about your personal preferences, but rather it is about representing the National Assembly as a whole. So yeah. And then just some case law that you can go and read up on, just in respect of various persons that actually sued the Speaker of the National Assembly on various issues, and again they were cited in that capacity. Moving on to the period of office for MPs, which are members of Parliament. So it's usually for the full term of 5 years until the next election. Because remember, the members of Parliament come in after an election because the membership is determined by the results of the election. So usually once they come in after an election, they will remain there for the full 5 years until the next election takes place. In terms of eligibility for election to the National Assembly as an MP, even though you are on the party's list, but if you do not comply with these two eligibility criteria, then you wouldn't be entitled to be a member of the National Assembly. And so firstly, you have to be a citizen, and second, you must be qualified to vote for the National Assembly. So those are the only two requirements. And I think this question comes up a lot about, okay, someone is sitting in Parliament, what education levels do they have? For example, if they are serving in the portfolio for health, do they need to be a doctor? No, none of that. Actually, the only requirement to be a member of the National Assembly is that you must be a citizen and you must be qualified to vote for the National Assembly. And yeah, that's it. Okay, so going to persons who would not be eligible for election as, or would not be entitled to remain a member of Parliament. Firstly, citizens who are appointed by or are in the service of the state and receive remuneration for that appointment or service other than the president, deputy president, ministers, deputy ministers, or other office bearers whose functions are compatible with the functions of the member of the National Assembly and have been declared compatible with those functions by national legislation. Secondly, permanent delegates to the NCOP or members of a provincial legislature or municipal council, they are not entitled to be members of the National Assembly. Unrehabilitated insolvents, anyone who is declared to be of unsound mind by a court of the Republic, anyone who after February 1997 is convicted of an offense and sentenced to more than 12 months imprisonment without the option of a fine, either in the Republic or outside the Republic, if the conduct constituting the offense would have been an offense in the Republic. And so here, colleagues, it wasn't in your study guide, but just consider the recent case of the Electoral Commission of South Africa versus Umkhonto weSizwe, political party and others, which is a case that was actually concluded this year in respect of Mr. Zuma and whether he was entitled to be an MP or not. And this specific section was actually invoked when they indicated that he was not entitled to be a member of parliament, because if we can recall, in 2021 he was sentenced to 15 months, so it's even more than 12 months. He was sentenced to 15 months for contempt of court, and he did serve some of the time, and he was ultimately pardoned by President Ramaphosa, or citing that the jails were full, essentially. So he didn't serve the entire 15 months, but he was still sentenced. And there was ultimately a lot of debate about whether he was eligible to be a member of parliament or not. It went to the electoral court, but then it ultimately reached the constitutional court, where they actually said that he was not entitled to be a member of parliament, because in terms of that section 47 of the constitution, he was actually convicted. It doesn't matter that he was pardoned. He was convicted and he was sentenced, even if he didn't finish serving the sentence. But the fact means that he was convicted and sentenced, and therefore he was not eligible to be a member of parliament. So that was the final say, even after the electoral court had actually indicated that no, because he was pardoned and he hadn't served the complete sentence, then he could form a member. The Constitutional Court actually overruled that and stipulated that in terms of Section 47, he's not entitled to, and therefore he couldn't be a member of Parliament. So yeah, very important, guys, to keep up with your current affairs, because sometimes when you're studying your cases and you can't remember specific cases, but one like this that would just be at the back of your mind, you can actually just include it in your answer, and there you get, maybe you might not get all your marks, but you can get some of them. So current affairs, very important. You'll see some examples of what we are studying here actually playing out in government. Actually, 9 out of 10 times you will see it with constitutional law, that it's things that are happening in the news. And then another type of person who would not be eligible for election is a member of the National Assembly or to remain as a member of Parliament, rather, is a member of the National Assembly who is absent from the National Assembly without permission, emphasis on without permission, in contravention of the rules of the National Assembly. So we talk about a period of more than 15 days. So if they are absent for that long, then they would cease to be eligible to remain a member of the National Assembly. Or they cease to be a member of the party that nominated him or her, then they will automatically lose their seat in the National Assembly. And then lastly, if a member of the National Assembly crosses the floor to another party, or if they are expelled from their party, they lose their seat in the National Assembly. Very important, guys. We've seen this play out. So most of you would have heard about Floyd Shivambu, how he left the EFF. He cannot carry that seat with him. So the seat that he had while he was with the EFF, now that he has left the EFF and crossed the floor over to MK, he does not, so he loses that seat basically. Our parliament does not allow for floor crossing and retaining your seat in parliament. Once you leave your party and you are a member of parliament, unfortunately you lose that seat. You cannot carry it over to the new political party that you are joining. In South Africa. In some other jurisdictions, they do allow for that, but in South Africa, we do not allow for it. If you leave or if you are expelled, you lose your seat. Okay, and then the sittings and dissolution of the National Assembly. As we indicated, it's elected for a period of 5 years unless the National Assembly itself has adopted a resolution to dissolve itself with the support of a majority of its members, and 3 years have lapsed since the Assembly was elected, so basically after an election. And then President must dissolve the National Assembly in these instances and set a date for election within 90 days of the date of dissolution, and we find that in section 50 subsection 1 of the Constitution. And then also where there is a vacancy in the office of the president because the president has either passed away, resigned, or was removed from office by the National Assembly in terms, of sections 89 or 102, then and the National Assembly then fails to elect a new president within 30 days after the vacancy occurred, the acting president must dissolve the National Assembly and a new election must be called within 90 days. So those are basically exceptions to the 5-year term of the National Assembly. That is how the Assembly can be dissolved before the 5-year period. And then in terms of the sittings, they may determine the time and the duration of its other sittings and their recess periods. So they have recess periods as well, and they can determine that, they discuss that and they agree on it, and then it's implemented. Okay, then going to the quorum and voting procedures. So decisions that are taken in the National Assembly are subjected to votes, and to effect the voting process, you actually need to have a minimum number of MPs that are present in the National Assembly before they can actually make a decision, go on a vote on a particular matter. So section 59 sets all of this out, different quorums for different decisions that would need to be taken. So just have a look at that section when you do have time. If a quorum is not met, then the speaker may suspend proceedings or postpone the decision of the question at hand. So if that specific quorum, so for example, if they say that a majority of the members of parliament need to be present and they're not present, then the speaker would then suspend those proceedings. That decision making or that voting wouldn't proceed until that quorum is present, or until the minimum number of MPs is present. And then the speaker has no deliberative vote, but has a casting vote in the case of an equality of votes. So what this means is basically that once everyone has voted, so everyone has a vote, once everyone has voted, the speaker does not have a second vote on any matters. The only time that they would have a second vote is if there was an equality of vote. So for example, 50 vote for, 50 vote for against. To break that deadlock, then the speaker would have a casting vote to actually say this decision should go ahead or this decision should not go ahead. So that is what is meant there by not having a deliberative vote, but having a casting vote. So the quorum for the passing or amendment of bills, at least 201 members, which is 50% plus 1. This is not 51%, colleagues. It's 50% plus 1 person. That's why you'll see that figure of 201. The quorum for any other questions, at least 1/3, which is 134 members, which equals 33.3, which is the equivalent of 1/3. The National Assembly can only remove the president from office by way of impeachment or amend the provisions of the Constitution other than Section 1, so except for Section 1, with a supporting vote of at least 2/3. So that's a 2/3 majority of its members, which is 66.6%. So if any decision needs to be made regarding the impeachment of a president or the amendment of the provisions of the Constitution, except for Section 1, then in order to pass that decision, 66.6% or 2/3 of the members have to vote in favor of that particular decision. And then the presiding member or speaker may cast a deliberative vote when a matter requiring 2/3 majority to pass is before the NA. So that's another exception to the speaker casting a deliberative vote. They can do so when a matter which requires 2/3 majority to actually pass. Then they would have a second vote in addition to their initial vote, just to implement that specific decision or vote against it. And then an amendment to Section 1 of the Constitution requires a supporting vote of at least 75% of the members of the National Assembly. That is a very high threshold in terms of Section 1, because Section 1 is actually the foundation of the Constitution. So it requires a higher threshold to vote for the approval of its amendment. So that is quorum and voting procedures, colleagues, in terms of the National Assembly. And moving on to openness and transparency. So the Constitution says that the National Assembly conduct its business in an open manner and hold sittings and those of their committees in public. So this has to be accessible to you. It has to be accessible to me. We should be able to see what is actually transpiring at the National Assembly in their proceedings. And then in this Doctors for Life case, they just enforced that participation by the public element, and they stated that participation by the public on a continuous basis provides vitality to the functioning of representative democracy. So it's that participative democracy that we talked about last week. This goes to the heart of it, ensuring the participation of the public in the making of laws. It encourages citizens to be actively involved in public affairs, identify themselves with the institutions of government, and become familiar with the laws as they are made. It enhances the civic duty of those who participate by enabling their voices to be heard and taken into account. It strengthens the legitimacy of legislation in the eyes of the people. And finally, because of its open and public character, it acts as a counterweight to secret lobbying and influence peddling. Public access to Parliament is a fundamental part of public involvement in the law-making process. It allows the public to be present when laws are debated and made. The opportunity to submit representations and submissions ensure that the public has a say in the law-making process. So again, usually you will see this before an act is actually enacted and it's legislated and becomes binding. They'll put it out for public comment, and usually you or I, as the normal person on the street, will not comment on it. But if we are professors and if we study specific parts of the law, then sometimes we do make our representations to the National Assembly to actually say our view on this law is such and such and such, and we do not believe that this is appropriate. And they can take that into consideration. They're not bound by it, but actually they are just enabling the participation of the public so that they can hear those views, and so that the public can actually feel as if they are participating, and they are actually participating in the lawmaking process. Okay, then we've got the case of Prime Media Broadcasting versus Speaker of the National Assembly. And in this case, the Supreme Court of Appeal ruled that the use of a jamming device was unconstitutional and invalid. Section 59 of the Constitution prohibits the National Assembly from excluding the public, including the media, from a sitting of a committee unless it is reasonable and justifiable to do so in an open and democratic society. This must be read in conjunction with Rule 57.1 of the Rules of the National Assembly, which regulates possible limits on the openness and transparency of the National Assembly by stating visitors must be admitted to those parts of the National Assembly which are called public galleries that have been set aside for that purpose, and only the Speaker may regulate same. So very important. The media, as you know, in order to give us information, they're always at the forefront of actually attending these parliamentary sittings. And in this case, there was use of a jamming device, which resulted basically in the media being excluded from certain portions of the proceedings that were being held in the National Assembly, and that is why this broadcasting house actually approached the courts to say that we are entitled as the public to actually have line of sight as to what is going on in the National Assembly, and the use of jamming devices is therefore infringing on that participation element. And the courts actually agreed with this and said that, yeah, the Parliament and the National Assembly needs to be accessible. To ensure participation, to ensure public involvement, it needs to be open and transparent. And then we've also got the case of the DA versus the Speaker of the National Assembly. And in this case, during the President's 2015 national address, a member of the EFF rose on a point of privilege, stating, may we ask the President when he is going to pay back the money in terms of what the public protector has said? Will he pay by EFT, cash, or e-wallet? And after those remarks, the Speaker at Arms and Protection Services to remove those members from Parliament in terms of Section 11 of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act for creating a disturbance. And the DA actually challenged this and the constitutionality of this section in terms of the purpose underlying parliamentary privilege and freedom of speech, which is actually entrenched in Parliament. And the courts agreed, but they didn't amend the section. What they said is that it should be read differently. We need to look into what constitutes a disturbance. Just by an MP making these remarks, it doesn't necessarily constitute a disturbance. So they had a narrow interpretation of Section 11 to actually say freedom of speech is guaranteed. A disturbance would not necessarily arise when someone makes certain comments, because that freedom of speech is guaranteed. So the courts did actually agree with the DA there by saying that the Speaker was wrong there in removing those members from Parliament, because they did have the right to freedom of speech, and they were not necessarily causing a disturbance by raising those concerns or making those remarks. Okay, so that's just to openness and transparency. Okay, then coming to the privilege that we've been talking about, colleagues. The first one is freedom of speech, meaning that MPs can say what they want to say. It should be open to them to say whatever they feel they need to express. It's not absolute though, but they freedom of members of Parliament. Then there's also freedom from civil or criminal proceedings, arrest, imprisonment, damages for anything they have said or done in the National Assembly or National Council of Provinces or one of their committees. And the reason for this is to enable MPs to speak freely, uninhibitedly, and to be able to do their work and expose wrongdoing without the fear of being held legally liable for what they say. So this freedom is guaranteed to them so that they can actually be able to carry out their functions. They can actually be able to debate effectively. When new laws are being raised, they can express themselves freely without fearing being punished in any way. That is the reason why they are basically immune from civil or criminal proceedings in this regard. But as with most things, this right is not absolute, or this freedom is not absolute. These privileges do not preclude the judiciary from inquiring into whether the procedures or limitations adopted by Parliament comply with the Constitution. So as much as the freedom of speech is guaranteed, it doesn't stop the judiciary from actually inquiring as to whether certain things that have been said or certain things that have been done are not in compliance with the Constitution. Because remember, the Constitution is supreme. All conduct and all laws have to be in compliance with it. So that doesn't stop the judiciary from actually investigating or adjudicating such type of matters. Sorry, not investigating, but adjudicating rather, such type of matters. To ensure that the Constitution is being complied with. Then just going to the Delil case, the High Court held that under Supreme Constitution, the exercise of parliamentary privilege is subject to judicial review because the National Assembly is an organ of state and therefore bound by the Bill of Rights. So basically bound by the Constitution. All its decisions and acts are subject to the Constitution and the Bill of Rights. Accordingly, the nature and exercise of parliamentary privilege must be consonant with the Constitution. The exercise of parliamentary privilege, which is clearly a constitutional power, is not immune from judicial review, and redress may be sought by an aggrieved party from law courts. So yeah, on the one side of the coin, you do have that freedom, but on the other side of the coin, the freedom has to be exercised responsibly because it can still be subject to judicial review to determine whether it's in compliance with the Constitution or not. And then very important, colleagues, parliamentary privilege does not extend to personal matters. So for example, if two members of parliament are outside of parliament and one insults the other, that is not being done within the realm of the National Assembly, and therefore it wouldn't be covered by this privilege. This privilege is in respect of when MPs are sitting and they're actually performing their functions within the realm of the National Assembly. So yeah, it's not absolute. If things are happening outside or crimes are committed outside which do not relate to the MP's function in relation to the National Assembly, then those wouldn't be covered by these specific privileges that we've mentioned here. Okay, then again, we talk about one of the functions of the National Assembly being holding the executive accountable. And Parliament is obliged to hold the President and other members of the executive accountable, even extending to the possibility of the President and members of the executive being voted out of office through a motion of no confidence or impeachment. So Parliament does actually have that power to remove the President or any member of Cabinet. Parliament is required to put effective mechanisms in place to achieve that objective. Courts can order the National Assembly to hold the President or the executive accountable after making a finding that it had failed to do so, as it did in Economic Freedom Fighters, and that's another case that you can have a look at, where the court held that the National Assembly had not taken appropriate action against the President, consequent upon the public protector having found that the President had unduly benefited when non-security related upgrades had been made to Nkandla out of public funds, and that he should pay back what was owed. So here the public protector actually compiled their report. They submitted that to the National Assembly, but nothing was actually done, or not to the satisfaction of the EFF at the time. And the principle that arose here is that the courts can actually force the National Assembly to take action when things like this happen. They wouldn't prescribe what type of action must be taken, but they can just indicate that action needs to be taken. So yeah, that's how the executive can be held accountable. And then in terms of specifics as to how the executive can be held accountable by the National Assembly, they can call members of the executive and the public administration to account for their activities. They can take remedial action and even dismiss members of the executive who fail to account properly for their actions, including an impeachment in terms of Section 89, subsection 1, and this is for serious misconduct or an inability to perform, or a vote of no confidence in terms of Section 102, and this is a political power, and it can be used for political reasons. And the majority party in the National Assembly or any of the other minority parties are not actually allowed to block the tabling or the discussion or the consideration of a voting of no confidence. And this was a principle that was actually discussed in this case of Mazibuko versus Sisulu and another, where the motion of no confidence was raised and then it was blocked, and they said you can't actually do that. It can be raised and then it would need to be deliberated upon. You can't just block it from being raised. Any party or any member of parliament can actually table that motion. And then oversight over executive. So this is basically oversight over the day-to-day exercise of authority and implementation of legislation. Just a classical example is what we saw with that antiretroviral drugs issue, where the courts actually had said that, oh, sorry, no, that was just the judicial exercise. But yeah, the day-to-day exercise of authority and implementation of legislation, policies, because Parliament would, or the National Assembly would then enact legislation, and they would expect that the executive would actually implement that in terms of the various portfolios at play. Okay, then moving to the National Council of Provinces, colleagues. This is the second house of the national legislature, and again, as I have reiterated, it is at the national level. It's not at the provincial level. So it comprises 90 members. It is elected via provincial legislatures. The 90 members represent a single delegation from each of the 9 provinces, each consisting of 10 delegates. So basically, it would be 10 members from each province, making up the number of 90. And the 10 positions in a provincial delegation are allocated proportionally to various parties represented in the provincial legislature in question, in accordance with the relative strength of the parties. For example, if the ANC received 60% of the seats in that legislature, then it would get 6 seats in the National Council of Provinces. Then the 10 members of each provincial delegation are classified. Yeah, so this number of 10 is divided into 4 special delegates and 6 permanent delegates. So the composition of the latter can be changed from time to time, depending on their expertise or special knowledge of a matter being considered by the NCOP in each provincial delegation. So these 4 special delegates, one of them has to be the premier of the province, and then the other 3 delegates are just selected from amongst the other members of the provincial legislature. The premier will then head the delegation. So each premier will head the delegation in the National Council of Provinces. They'll head the other 9. And then these 4 delegates remain members of the provincial legislature. And in other words, they are simultaneously members of the provincial legislature and members of the national parliament, acting as special delegates to the NCOP. So that's what makes them special delegates, that they still form part of the provincial legislature. The permanent delegates cannot simultaneously be members of the provincial legislature and permanent delegates to the NCOP. They are selected from either from among party members not elected to the provincial legislature, or from among members of the provincial legislature, in which case they automatically lose their seats in that legislature. So these permanent members are only part of the National Council of Provinces. They can't be simultaneously part of a legislature at provincial level and also members of the NCOP. But the special delegates are entitled to actually be members of both. So that is the distinction between the 4 special delegates and the 6 permanent delegates. All of the National Council of Provinces, very important, they represent the provinces to ensure that the provincial interests are taken into account in the national sphere of government. That is their most important function. So they give input in respect of the province which they represent. So for example, if a law is being debated and it, for example, relates to water, for example, we know that there were significant issues with the provision of water in the Western Cape. So if a law is being passed regarding water, the Western Cape would have something different to say about it as to what should take place than what Gauteng, for example, would want to say or would put forward in terms of the law that is being proposed. So the National Council of Provinces serves that function to give perspective as to what each province, their views are on specific legislation, because it does affect them. And then their second function is to participate in the national legislative process and to provide a national forum for public consideration of issues affecting the provinces. And that links in with point number 1. So they bring perspective as to what their specific province would like to be considered. And that is their function, because the provinces are different. They've got different needs. They've got different bylaws. They've got different ways of doing things. So we need that perspective, especially when enacting legislation. So it also has committees to oversee its work. It's got a presiding officer, which is known as a chairperson, and then 2 deputy chairpersons are also elected. An Act of Parliament must provide for a uniform procedure in terms of which provincial legislatures confer authority on their delegations to vote on their behalf. The National Council of Provinces may not be dissolved. So it's not like the National Assembly that can just be dissolved by a vote of the members. It's actually a perpetual body without a fixed term. And then in terms of the members, permanent delegates are linked to the provincial legislature. They represent and may be recalled, whereas special delegates are appointed from time to time and generally serve for short periods of time. Yeah, so that is just in relation to the function and the role of the NCOP and how its members are actually elected. Okay, and then going to the powers. So in terms of internal affairs, the NCOP has the power to determine and control its own internal arrangements, proceedings, and procedures, including the composition, powers, and functioning of their committees. They can hold the executive accountable. In terms of Section 69 of the Constitution, the NCOP can summon any person, including the President and Cabinet Ministers, to give evidence under oath or affirmation, or to produce documents, require any person or institution to report to it, compel any person or institution to comply with a summons or requirement to produce documents, and then to receive petitions, representations, or submissions from any interested persons or institutions. And then we've got voting in respect of legislation, which the NCOP partakes in. If the legislation to be passed does not directly affect the provinces, the NCOP members each have an individual vote, so per person, which they cast in accordance with the wishes of their respective political parties. Then in all other cases, including when amending the constitution or dealing with bills affecting the provinces, each provincial delegation casts a single vote under instruction or mandate from the provincial legislature. So it wouldn't be the 10 representatives of the province voting. It would actually just be 1 vote per province. So Limpopo will have 1 vote, Eastern Cape will have 1 vote, and so forth. And then oversight. So they can review the intervention of the national executive in a province and the provincial executive in a municipality. It must approve a decision by the Treasury to stop the transfer of funds to a province, or a decision by the President to declare a state of national defense. Additionally, the NCOP resolves disputes concerning the administrative capacity of a province. So yeah, they exercise that oversight function, which is one of the important functions as well of the NCOP. And then the limits on the powers, colleagues, you will see that this is identical actually to the National Assembly. It speaks to the same thing, and it just indicates that the NCOP must act in an open and transparent manner and cannot make rules contrary to the constitutional requirement of openness. So it's what we discussed at National Assembly level as well, that everything that the NCOP does must be open to the public, and it must be transparent. And then members of the NCOP, as well as cabinet members who appear before it enjoy certain privileges. Those are the ones we discussed, which cannot be curtailed except in those specific instances that we referred to. And then the NCOP is required to facilitate public involvement in its legislative and other provinces. Exactly like the National Assembly, the public needs to be able to give comments on matters that are before the National Council of Provinces, and there needs to be that call for public comments, especially with bills and the like. So yes, colleagues, that brings us to the end of our tutorial for today. As I indicated, I'm going to continue with chapter 4 tomorrow. There's just one topic left that we need to discuss under chapter 4, and that is the passing of legislation, how that process actually plays out. And then once we've discussed that, then we will immediately move on to chapter 5, being the executive. So before I go to the class activity, I think Mr. Patrick, you had a question that you had raised.
Yes, ma'am. Thank you very much.
Yes.
I won't be long. It's only 2 questions that I want some clarity on.
Yes.
The first one will be the recordings, because
yes.
you know, I tried to open the recordings. It is there, but it doesn't open. I don't know what the problem could be. That's number 1. Number 2 is that I haven't heard much about, you know, members of the of parliament that participate in the oversight committees. What is the criteria and what is the requirement for that? That was not touched. Maybe I did not hear you, but I needed to understand what is going on. Thank you. Those are the 2. Thank you very much.
Oh, okay. Then firstly, with your question regarding the recordings, I did indicate in the beginning of the tutorial that the recordings will be made available to you, so you won't be able to just go into your Teams, download from that link, and then be able to have access to the recording. What UNISA actually does is that they need to edit the tutorials and the recordings so that it can meet their standards, and then the link will be made available to you to access that. So that from what I've been advised, it takes about a week or so. So please just do be patient with the academic personnel. They will make that link available to you so that you can have access. But what I am still going to do, which is what I also did last week, is I'll provide these slides to the tutorial officer, and he will then distribute them to all of you. So I did provide last week's ones, and I'll provide this week's ones as well while you wait for the recordings. And then your second question was regarding oversight, was it?
Yes, correct. Because I want to know what is the criteria for somebody to become, you know, the chairperson of SCOPA, you know, things like that. Thank you.
Yeah, they would obviously look at the relevant qualifications.
Oh, okay.
That I can give you a clearer answer tomorrow, but there is different criteria that they look at, and they always put it to a vote, which is what we should remember. So if they feel that a specific person would fulfill a specific role, or they would be qualified, then that would be put to a vote, and they would all agree that that person should actually be appointed. But I will give you a more defined answer tomorrow. If you are in tomorrow's tutorial, I will get back to you on that one, on the specific criteria, because we don't really go that in depth in terms of the module, but it is good knowledge to actually have, just in terms of understanding the workings and these appointments and how they work and how the oversight works. So I will revert to you with a more detailed answer on that.
I'm so happy that you will be providing the slides. Because
Yes.
I'm in love with your slides, the manner in which your presentation is coming. I'm very happy.
Thank you. But you'll be surprised to note that literally this is the material directly from the textbook read together with your study guide. It's just presented in an easier format so that we can have a discussion around it. But everything I'm mentioning here, colleagues, is actually included in your study guide. So if you need to read further, I have given you the page numbers with some of it. But if you feel that you need to read further on a specific topic, it is available in your study guide or the textbook. But yes, these slides will be made available to you.
Okay, my question is on the election side, on the
Yes.
electoral side. Since
Yes.
our election was based on a closed party proportional list whereby we only vote for the political party.
Yes.
But in the previous election, the president passed the law which says that the individual must also join, they must contest election as individuals.
Yes.
So what then does it say to that closed party proportional list now in the Electoral Commission? Although their performance was not that good, but they were individual were running for elections.
Yeah, so it doesn't actually alter. That's a very good question. It doesn't actually alter it in any way. It would still be a matter of thresholds. And where do we get our thresholds? In terms of the votes. So as much as an individual, yes, in terms of that case, they are entitled to contest. You and I would be entitled to contest. If we are not getting the required votes necessary to actually give us a seat in the legislature, then it still closes out our participation. So it hasn't altered it in any way. It still works. The rules still apply in the same way. It's just that we're not seeing that representation merely because our individual or our independent persons who are actually participating are not gathering enough votes to actually entitle them a seat. And I don't know about you, but my view is, I mean, it wouldn't be fair. I mean, for other countries, fine, where you've got two people who are up against each other and you just have to decide between 2, 3, 4, 5 people. But if it's you yourself and you are up against all these political parties, I feel as if there should be actually rules that would give you sort of a step forward, to enable you to actually participate. Because you're right, we're not seeing them represented. It doesn't alter the rule in any way, but merely because they're not getting enough votes, we're not seeing that representation in the legislature. I hope that answers your question. But yeah, for me, I would also think that they should change the rules in such a way that those that are participating as individuals or those that are putting themselves forward to be elected as individuals, they should receive some form. Maybe we should say we reserve 2 or 3 seats for them or something along those lines. That would be my view. But yeah, it doesn't change the rule in any way. It's just that they're not garnering enough votes to actually get a seat.
Okay, thanks very much.
Thank you. Does anyone want to give me an answer on the first question? Please give an example of checks and balances and who it is exercised by. So with the separation of powers, we spoke about checks and balances that branches of government exercise over one another. Can you give me an example of those checks and balances and who exercises them in the last 4 minutes?
So just to answer the question,
yes.
So examples of checks. So I've just given examples. So for instance, if Parliament passes a law,
yes,
that is questioned for potentially violating the Bill of Rights, for instance.
Yes.
Right.
Yes.
And then the court will then examine that law against constitutional standards. So I feel that's an example of balance and checks.
Yes. Yes. 100%. That is correct. The courts, and in fact, that is the most common type of checks and balance that we see in South Africa, in particular, where courts, where laws will need to pass constitutional muster. They need to comply with the Constitution. So we see the courts actually invading the space of the legislature and actually saying this law that you've passed, it's got provisions that appear to be unconstitutional or that are unconstitutional, and therefore they refer it back. So yes, 100% correct. and just important to remember with that example, colleagues, is that the courts will not rewrite that law. They will never rewrite law. They have to refer it back to Parliament so that Parliament can either do away with the law in its entirety, or that they amend the offensive provisions that are not in compliance with the Constitution. Okay, last question. Anyone? The 3 limits on the powers of the National Assembly and the National Council of Provinces. Would anyone like to give it a try? So these are the limits, and it applies to both the NCOP and the National Assembly. These are the limits on their powers. They must always act in an open and transparent manner. That is a limitation on what they do. The members enjoy certain privileges which cannot be curtailed. So these cannot be curtailed by any other member or anyone else. And then both the National Assembly and both the National Council of Provinces are required to facilitate public involvement in their legislative processes, meaning that when a law is being enacted, the public actually needs to be given an opportunity to give comments on how they feel about that specific law. Okay, we are done with today's tutorial. Thank you guys so much for the participation. So tomorrow's topic, as I said, it's going to be a continuation of the National Legislature. There is just one topic that is left under that chapter. I mean, it's in relation to the passing of legislation. So it's basically the process that is followed when legislation is being passed, how it arises, how it's debated, your green paper, your white paper, and then it eventually being an act that is binding on everyone. And then we'll be moving on to chapter 5, which is the executive. So we're going to start and finish the executive tomorrow, and then it will just be the last part of the national legislature, which is chapter 4.